Thank you, Madam Speaker. Will the sponsor yield?
He indicates he will.
Leader, if you could, what is the reason behind bringing this bill?
Well, as I indicated, I think more recently than ever, over the past 3 years, the Attorney General's office has been forced to respond to, I would call them in many cases, frivolous lawsuits that have strained the office's limited resources. And I believe that many cases it has been a result of job shopping, which is a tactic that has been used by many litigants to secure sweeping court orders blocking state policies by steering cases to judges perceived to be sympathetic to their causes. We're limiting this to constitutional issues, and we're saying that Sangamon County or Cook County would be the proper venue. These cases are normally all coming here anyway, so let's just say that the original venue is going to be here.
So part of it is the Attorney General's limited resources in dealing with these actions. Is that what I understood you to say?
Yes.
This is the same Attorney General's office that has requested from this body additional authority to investigate and bring actions against crisis pregnancy centers this session, to bring actions against and investigate gun manufacturers this session. It doesn't seem that the Attorney General's office is lacking in resources when they're constantly coming to this body requesting more authority to do things. So I think that argument strains credulity.
What was that word?
I'm not sure.
Credulity? What did you, okay, interesting.
I'm trying to test the typist upstairs.
I can tell you what the Attorney General's office, how they responded in committee. They indicated that these are constitutional actions. They have certain constitutional lawyers that are specializing in these types of actions. So when you receive last-minute notices about a county that is far away from where these constitutional officers or constitutional lawyers are working, that it's very difficult to respond adequately.
Well, the Attorney General's office, as you know, has offices throughout the state. In fact, I believe there are 10 offices outside of Cook County itself that are statewide. So from my perspective, it appears the Attorney General has adequate resources and adequate personnel to deal with these issues. And in fact, as I said, they've been coming to us repeatedly this session requesting more authority. So for this argument does not, in my opinion, hold any weight. So you're familiar with the Matthews balancing test, which was used in Williams versus Illinois State Scholarship Commission?
I'm familiar with the case.
Yes. And in that case, a venue restriction was held to be unconstitutional?
It's my understanding, yes.
Saying that it violated due process?
Yes, but there are distinctions between this proposal and that ruling. If you would, I can point them out.
Go ahead.
Okay. The Williams case dealt with a defendant. They were essentially being deprived of access to court because they were deemed indigent. And they were talking about defendants here, okay? They're talking about providing that a defendant had to go to Cook County. It didn't indicate in this case, what we're talking about is constitutional matters. The defendant is the state, right? So the distinction is in these cases, what we're talking about is we're talking about the plaintiff, not the defendant being inconvenienced, which was the Williams case.
So in my community, if this body passes a constitutionally questionable piece of legislation, which we appear to do routinely, that results in a court challenge, people from my community will have to travel to Springfield to challenge that action. It cannot challenge that in Massac County. Is that accurate?
Under this proposal, Sangamon and Cook would be the proper venue. And incidentally, this is not uncommon. We've done it in several instances where we have provided that Cook or Sangamon County would be the proper venue. For instance, cases brought by the Attorney General to eliminate a pattern or practice of constitutional violations, cases brought by the Attorney General of Illinois to compel compliance with Section 3.5 of the Open Meetings Act, They also have venue in Sangamon or Cook County. Judicial review of certain final administrative decisions relating to the Collection Agency Act, and judicial review of certain final administrative decisions relating to the Community Association Manager Licensing and Disciplinary Act. Those are all venue would be in Cook or Sangamon County.
Well, I appreciate that list, but this is much broader than the list you provided. And this is going to have a much bigger impact on individuals in our various communities who want to get justice in their local community, rather than having to travel to Springfield or Chicago to get that justice. You know, where I live, I'm closer to the state capital of Tennessee than I am Illinois, and I'm almost as close to Atlanta, Georgia as I am Chicago, Illinois. So to say if this body passes an unconstitutional law, in order for me or another person in my community to contest that law, I've got to travel a great distance and bear that expense that comes with that, is not fair to the individuals in these communities.
Yeah, I believe, so this proposal would say venue is in Sangamon or Cook. If you were to prevail on constitutional issues, it's my understanding, many times the awarding party is given expenses and costs.
So I think the better explanation isn't the expense to the Attorney General's office, isn't the strain on their office, and maybe more about the judge shopping, basically getting rulings that are not favorable to the majority party. But I think the ultimate reason why this bill is being brought is because you can. You're bringing this forward because you can do it. And we are seeing efforts made to undermine the legitimacy of the court system by efforts like this. We redrew the maps for our appellate and Supreme Court because you could. You did that because you could. Something unfavorable happened in an election, and you changed the maps. You get an unfavorable court ruling where people legitimately go to their home court where they live and get a ruling that you don't like or your side doesn't like, and you change the rules. The ends do not justify the means. To the bill, we have seen many counties throughout our state pass resolutions saying, we don't feel a part of the state of Illinois. We don't want to be a part of the state of Illinois because they're passing these resolutions because they don't feel the respect from certain parts of the state of Illinois. And what this bill does is it basically says, you're right. You can't go to court in your local jurisdiction. You can't get justice in your local jurisdiction. You've got to come to Springfield or Chicago to get justice. And that is fundamentally wrong. I urge a no vote.
Representative Calkins is recognized.